Good morning, everyone, and welcome to Court Accountabilities and the Defend Democracy Project's virtual event on the Supreme Court's role in the upcoming election. We're so pleased today to bring you a set of top political and legal voices addressing this important subject. I'm Norm Eisen from the State Democracy Defenders, and my job is to introduce today's events, to lay out the agenda, and then I'll pass it to our first panel. We know that the election subversion movement and its strategy runs right through the judiciary because of the 63 failed cases that they brought in 2020 and the explosion of pre-election litigation that they've brought. We've never seen anything like it in American history. Public trust in the safety and security of our elections is imperative, but as part of securing that trust, we need to prepare seriously for the risk that the justice system, and in particular, the MAGA bloc on the United States Supreme Court that has delivered terrible decisions favoring the former president in a series of cases, perhaps most outrageously Trump v. US. We must be ready and steadfast to make sure that we do not see a continuation of that pattern. And that is why we are bringing you this all-star set of panelists today talking about the issue and what every American must do to be ready for this post-election litigation season, the risk and the responses. And there's no one better to kick that off. We'll have two panels. There's no one better to kick that off than I'm proud to call him my friend and my colleague, Judge Michael Luttig, who's going to be interviewed by one of the greats of the legal journalism field, Dahlia Lithwick. Judge Luttig served on the U.S. Court of Appeals for the Fourth Circuit for 15 years as an appointee of former President George H.W. Bush, confirmed by the United States Senate on a bipartisan basis. He'd previously been in senior roles at the United States Department of Justice and in the White House, the latter under former President Ronald Reagan. He was a law clerk to then Judge Scalia on the U.S. Court of Appeals for the District of Columbia, and a law clerk and special assistant to former Chief Justice Warren Burger. And there has been no more forceful or courageous voice, conservative, liberal, or otherwise, than Judge Luttig, who burst upon the national consciousness in the January 6th hearings and has been such an important voice of conscience and patriotism ever since. He'll be introduced by our friend Dahlia Lithwick, senior editor at Slate, the author of their Supreme Court dispatches and jurisprudence columns for decades. She also hosts Slate's award-winning biweekly podcast, Amicus, and is a best-selling author, including her recent book, Lady Justice, Women, the Law, and the Battle to Save America, an instant New York Times bestseller. Two better folks to kick us off for the first portion, and then we'll have our all-star panel, so stick around when Dahlia and the judge finish their fireside chat. Dahlia, Judge Luttig, over to you.
Thank you so much to Norm. Thank you to Court Accountability and Defend Democracy. And Judge, it's just always such a treat to be in conversation with you, even, here we are 3 weeks before the election. And I think I just wanted to start by asking you this one framing question, which is, if we start from the presumption that the Supreme Court has kind of already weighed in on the upcoming election, I'm quoting you telling the New Republic's Greg Sargent after the immunity case that already you knew it's unlikely that Trump will ever be tried for the crimes he committed in attempting to overturn the 2020 election. So I guess I'm wondering, even before we get to the sort of prospective conversation about what's coming, how much, if at all, does the fact that the court has made it impossible for there to be real accountability for 2020 figure into the court's role already in the upcoming election?
Dahlia, thank you for that question, and thank you, Norm and Dahlia, for the opportunity to be with you today. Both of you at this point are dear friends, and it's really an honor for me to be on with the two of you. Yes, of course, Dahlia, the Supreme Court has already weighed in on this election. It has done all within its power to ensure first and successfully that the former president would not be tried before the 2024 presidential election. And then secondly, it has done all within its power to ensure that the former president will never be tried for the grave offenses that he committed against the United States on January 6th and thereafter, both of which ensure to the maximum extent possible that the Supreme Court could ensure that Donald Trump will be elected to the presidency on November 5th, 2024. That's a lot, and we can parse through each and every one of them. But the headline, if you will, to what I just said is that the Supreme Court has done all within its power to ensure that Donald Trump is elected president of the United States again, and that gives us every reason to think that it will do whatever is necessary between now and January 2025 to ensure that Donald Trump is the next president of the United States.
Judge Luttig, I don't want to spend a lot of time on the three cases that the court has heard, because I think you've so kind of fulsomely critiqued them over the course of the summer. But I do want to give you a minute to reflect on all three of the Colorado ballot case, the Fisher case, and the immunity case that Norm discussed, only because I think you've described each of them as not just I think you described the Colorado case as a decision that disfigured the 14th Amendment. You described Fisher as, in your amicus brief as like through the looking glass, the law of Humpty Dumpty. And the immunity case, I think you actually, I saw you describe it as the Dred Scott of the Roberts Court, insofar as it put the president above the law. But I wonder if, without going too deep in the weeds of your critiques of that trio of cases, Judge, if you would just talk for a minute about sort of any through lines you see between, how the court set about doing what it did in all three of those cases.
Dahlia, speaking first to the Colorado case and also the immunity case, Trump versus United States, I consider both of those decisions as a betrayal of the Constitution of the United States and of America at this particular juncture in American history. Turning first to the Colorado case, there's no question whatsoever under the plain terms of Section 3 of the 14th Amendment that Donald Trump became disqualified from the presidency on January 6, 2021, and is to this day disqualified from the presidency. What did the Supreme Court hold? It would be impossible to say what the Supreme Court held. What we can say, though, is that it refused to decide the issue. In effect, in the end, sending the case to the Congress of the United States to decide, in the first instance, literally every single one of the 4 or 5 fundamental constitutional issues that are raised under Section 3 of the 14th Amendment. The Supreme Court of the United States was established in the Constitution in order to decide cases exactly like the 14th Amendment case. And then in deciding that case, as you alluded, the Supreme Court disfigured, I don't think I used that word, but that's apt. It rewrote Section 3 of the 14th Amendment, and therefore the 14th Amendment itself, in ways that were indisputably not intended by the framers of Section 3 of the 14th Amendment. Turning to the immunity case, the Supreme Court literally held that the President of the United States, and in particular, Donald Trump, the former president, is immune from prosecution for essentially all crimes, any and all crimes that he committed or would commit if he's elected in November. That is, any crime that he committed that was arguably in furtherance of his official responsibilities as President of the United States. Before Trump against the United States, not one single person since the founding of the country, and especially not one single constitutional scholar or student of the Supreme Court, had ever as much as suggested that a president of the United States would be immune from prosecution for any crime whatsoever, let alone for every single crime that he or she commits. We know that this decision was written solely for Donald Trump to ensure that he would never be prosecuted and convicted for the grave offenses that he committed on January 6th. It would never have been written but for Donald Trump. Then the third of the trilogy is Fisher. I don't regard Fisher as in the same category as the other 2 cases, frankly. I disagreed with it for the reasons that I set forth in our amicus brief with my colleagues that we can go into. But I would, for today's purposes, I would call Fisher nothing more but nothing less than a typical Supreme Court decision, though in the context that we're talking about today, it was a further insurance that Donald Trump will never be convicted of the charges for which Jack Smith has indicted him.
So, Judge, to the extent that our task this morning in this conversation is to try to understand the extent to which things have changed in the intervening 4 years since, as Norm Eisen said at the top, 63 cases, the court refuses to get involved in any of the election cases. The story we tell about the 2020 election is that the justice and judicial system held, that it worked. And I think the question that I want to animate the rest of this conversation is, has that changed? To the extent that you think it's changed, how much of that is a function of those decisions we just talked about? Are we in the same world where we can be confident that if whatever the Bush v. Gore or whatever case, I know the next panel is going to talk about what those cases look like, go to the Supreme Court, can we be confident that the same court is going to behave in the same way? Or do we have this new data that suggests, as you said, that the court seems to be at least somewhat invested in protecting Donald Trump?
Oh, well, Dahlia, of course, that's the question of the day. But first, I don't really agree with your thesis, and for this reason. I've said this publicly many times now, but it's not been picked up because it's so far down the line of priority. But I do not believe January 6th would have ever occurred had the Supreme Court stepped up in the fall of 2020 and decided the independent state legislature theory. Once the court refused to decide that case, which came up from many courts of appeal, several courts of appeals, including, from relating to Pennsylvania, I think was the final, and the court decided to deny cert. The die was cast for January 6, 2021. And then, of course, as soon as possible after that, after January 6, 2021, the Supreme Court took the case and the issue and decided more against Harper in a way that I believe would have prevented the January 6th. But putting that aside for the moment, the next caveat that I would make is that we don't have the same court today that the nation has had for almost 250 years since its founding. So it's not, for me, so much a question of do we have the same court today as we had in 2020. It's simply that we have a much different court than we've ever had in our history, and then specifically on the issues that will come up between now and January 6, 2025. And as to that court, there should be no question whatsoever as to where it will be going in the cases that do come before it between now and January 6th.
Okay, well, that's quite despondent making. I guess I had hoped for a slightly more ambiguous answer, but I don't disagree with you. I do want to ask you, when I read your thoughts in advance of the cases that we've discussed, the trilogy of cases, with the understanding that Fisher is a very different, a different kind of case, but you rooted all of your analysis and your interpretive strategies, in originalism, in textualism, in text and history and meaning. And it does raise, I think, for people who think about you as somebody who has really broken away from the conservative legal movement, it raises this question of, is the court just getting originalism and textualism and text and history and meaning wrong? And I remember once asking Justice Stevens in an interview how he became, a left flanking member of the court. And he said, the court moved around me. And I sort of want to ask you the same question. Did the conservative legal movement move around you in terms of the meaning of textualism and originalism in history?
No. The current Supreme Court doesn't follow if it even believes in originalism and textualism anymore. We know that as a matter of interpretive fact, if you will, from, if nothing else, the two of the three decisions that we talked about. There was no support whatsoever in the Constitution of the United States or the laws of the United States or in originalism for the immunity case. By the same token, there was nothing in the Constitution or laws or originalism or textualism that supported the Supreme Court's indecision in the Colorado case. Today, what we know is that the Supreme Court picks and chooses the times when it wants to rely upon originalism and even textualism to meet its objectives at that moment. I said, actually, when the Supreme Court decided the Bruen case, the Second Amendment case out of New York, that the only silver lining was that originalism was a dead letter. And that turned out, in my view, to be more than prescient. But it began with the Bruen decision, which was, I also wrote an amicus brief with my colleagues in, and it was purely based on originalism. And the court's decision, written by Justice Thomas, was unrecognizable to me and my colleagues as an opinion of originalist interpretation of the Constitution of the United States.
Judge, I've heard you say over and over again that the single most salient issue for you thinking about going into the 2024 election is democracy, continuing democracy, peaceful transfer of power, the rule of law. And I wonder if you think that the American public fully understands the enormity of that question, or if it's just too much of an abstraction. And then I guess my part B, this is a Stephen Breyer multiple part question, but my part B is, do you think the court fully understands that democracy, peaceful transfer of power, and the rule of law are very, very much the thing that is at risk in this election?
I love that question, Dahlia, and literally right before I came on today, I finished an essay that we'll publish soon on the election, American democracy, and the rule of law. And the highlight of that essay is that Donald Trump and now the Republican Party have corrupted American democracy and the rule of law. And therefore the question, and therefore the election in November is a test of Americans' commitment to their democracy and rule of law. Now, turning to the Supreme Court, not only do I not believe that they understand that, I believe they fully understand it, and they categorically disagree with it, Dahlia. There's nothing else that would explain the decisions that we've been talking about. And by the way, it's not for today, but I've attended these oral arguments in these cases, and some of the questions from some of the justices betrayed that very thing, that those justices at least don't accept that any of this is about American democracy and the rule of law. Now, they're simply wrong. And it's reprehensible, in my view, for any judge, frankly, any person, to say that this election is not about American democracy and the law and the rule of law. Now, turning to the abstraction point that you raised, I have written, and it may have been, I think, in my endorsement of the vice president, that the political talking heads and the political operatives tell us all the time that American democracy and the rule are too abstract for the American voters. Well, I don't believe that's ever been true, but if it has, it's certainly not true today. Donald Trump tried to overturn a presidential election in 2020. That's perhaps the gravest offense that can be committed by a president of the United States. And today, he and his Republican, obeisant Republican Party persist in their false claim that he won that election. And Dahlia, today, the former president and his Republican Party refuse to tell the American people that they will accept their vote and their will in the election that's coming up in only days. The American democracy and the peaceful transfer of power are the fundamental tenets of our constitutional republic. And Donald Trump and the Republican Party today are threatening America. They're holding America hostage for another January 6th when they say that they will not respect the will and the vote of the American people unless Donald Trump wins. That's abhorrent, but many, many millions of people, Americans who are Republican or Republican leaning, I believe, they like that position that's being taken by Donald Trump. For the life of me, I cannot understand it. But I can tell them one thing: this is the moment, the man and the moment in American history that our founding fathers and the framers of our Constitution feared more than anything else in the world.
Judge Luttig, I just want to add my voice to Norm Eisen's and to say I don't know of a lot of people who have done more than you have and staked more of your skin in the game to make this very point. And it's just always a treat to be in conversation with you, and always really just an honor to see the work that you've done. So thank you for joining us. And with that, I'm going to turn us over to Mike Sachs, who's going to shepherd along the second panel. Thank you, Judge.
Thank you, Dahlia. Thank you, Norm. And wish I could stay with you, Mike Sachs, but you're going to have fun talking to Mike.
Thanks, Judge.
Enjoy the rest of your day.
Thanks, Judge, and thank you, Dahlia. Wonderful panel, wonderful Q&A, and always a pleasure and often quite scary to hear what they have to say about what's coming up and what has already happened in our legal system and our political system leading up to this election. I'm Mike Sachs. I'm a senior advisor with Court Accountability, and this panel is going to be pretty strong, quite strong exploration of the election interference threats heading up towards the Supreme Court as we speak. Joining us with us right now is Aziz Huq. He's a scholar of U.S. and comparative constitutional law. His recent work concerns democratic backsliding and the regulation of AI. His award-winning scholarship is published in several books and in leading law, social science, and political science journals. He also writes for Politico, The Washington Post, The New York Times, and many other non-specialist publications. In 2015, he received the Graduating Students Award for Teaching Excellence. He's at the University of Chicago. He has active pro bono practice. He's on the board of the American Constitution Society, the Seminary Co-op, the New Press, and the ACLU of Illinois. Welcome, Aziz. We also have with us Lisa Graves. She's the Executive Director of True North Research, Court Accountability's sister investigative watchdog group. Lisa works with journalists and others to shine a light on those fueling regressive agendas targeting our freedoms. Lisa is one of the nation's foremost experts in exposing how special interests distort public policy and try to thwart the public's interest in a thriving democracy and a healthy planet. And Lisa is also the president of the board of the Center for Media and Democracy and a trustee of the Park Foundation. Also joining us is Adam Bonin. He extensively represents clients in campaign finance, election law, pay-to-play, official ethics, and lobbying compliance matters, and has been a leader in efforts on behalf of the rights of online speakers. He's been successful on both sides of the ballot access battles, successfully representing candidates for office and defending their right to appear on the ballot, as well as removing others from the ballot whose signatures have been procured fraudulently or unlawfully, and has successfully aided clients in post-election recounts and litigation as well, including 2 tied elections for local office. And then finally, I hate saying last but not least, but it especially applies here, is Madiba Dennie. She is an attorney, columnist, and professor whose work focuses on fostering an equitable multiracial democracy. Dennie is the deputy editor and senior contributor at the critical legal commentary outlet Balls and Strikes. In her previous role as a counsel at the Brennan Center for Justice, she provided legal and policy analysis regarding a range of democracy issues, including the census, the courts, and attempts to disempower communities of color. Welcome all, and everyone watching at home. I wish give them a hearty round of applause that we cannot hear because only you can hear us. But we all hear it and are happy you are joining us to watch this panel. Now, I want to start with Aziz. Aziz, your recent Politico piece is called "Why the Supreme Court Might Case the Final Vote for President." Now, of course, that conjures up Bush versus Gore flashbacks from 24 years ago. Are we staring down another scenario now where the Supreme Court might pick our president above and beyond the will of the people?
Hi, Mike, and it was a pleasure to hear Judge Luttig and Dahlia just now, and that was a real treat to hear, in particular, Judge Luttig's diagnosis and description of the situation. I think the way that I would build on what they said would be to maybe lay out the pathways whereby the Supreme Court could take up a case that was decisive with respect to the 2024 presidential election. I think that the specter that looms over that question is, as you said, Bush v. Gore. And Bush v. Gore is indeed the canonical or the most obvious pathway for the court to take up an election-related case in short order and issue a ruling that decides the election. Bush v. Gore, recall, was an appeal of a federal law question from the Florida courts directly to the Supreme Court. This is the meat and potatoes of what the Supreme Court does. It hears cases concerning contested questions of federal law from either state courts or federal courts. And certainly, as Norm Eisen has shown in the tally that he is keeping on just security of election-related cases, there are almost a dozen cases floating around in state and federal courts raising federal law questions which might impinge upon the election. But since Bush v. Gore, there have emerged at least 3 other pathways for the court to interfere or to pluck an election dispute out of the political process and decide that case in a way that is outcome dispositive with respect to the election. And let me lay those out because I think it's helpful for people to know just what the lay of the land is. So the first concerns questions of state law. Now, most lawyers or law students will know that the Supreme Court is a federal body. And its jurisdiction, its power to decide cases, is limited in almost all cases to federal law questions, questions of federal statutes or federal constitutional law. However, in a case called Moore v. Harper, which Judge Luttig mentioned, the court, for complex reasons that I won't go into, held that there was some class of cases in which a state Supreme Court issues a ruling on state election law, and the Supreme Court can intervene and say that the state Supreme Court's ruling on state election law is so wrong that the federal Supreme Court has the power to reverse it. So Moore v. Harper has a kind of loaded gun in it, which allows the federal Supreme Court to transform a question of state law into a question of federal law that it can decide. And the boundaries of this transforming category are entirely unclear from the text of Moore v. Harper. So that pathway where state law issues can become federal law issues, can become things the Supreme Court can decide, simply did not exist at the time that Bush v. Gore was decided. So that's the first pathway. The second pathway is, I think, an inadvertent side effect, of reforms to the Electoral Count Act. The Electoral Count Act was a statute passed in 1887 that, as its name suggests, describes the way in which electoral college votes are counted in the days after an election. The 1887 statute, however, was hardly a model of congressional draftsmanship. It was a very confusing and poorly drafted measure. Congress amended the Electoral Count Act in 2023 and imposed much needed clarity. However, one of the changes that they made to the Electoral Count Act creates at least a possibility of litigation and deep uncertainty. Under the pre-2023 Electoral Count Act, when a state submitted its slate of electoral college votes to Congress, it had to do so by a safe harbor, which was in early December. I believe it was December the 5th. And if the state failed to meet that safe harbor, it's not that its electoral college votes were not counted, it's that those votes were no longer treated as being conclusive as a matter of law. The recent amendment to the Electoral College Act, however, says that a state must submit their votes by a safe harbor of December 6th. And the statute does not, unfortunately, say what happens if electoral college votes are delivered after December 6th. That gap in the statute creates an important kind of legal uncertainty. It creates uncertainty which invites efforts to delay the certification of electoral college votes, potentially in states that are decisive with respect to the Electoral College. Think here of both Georgia and Arizona, where you've seen something of this, of the groundwork being laid for this, although there's been pushback even in the last couple of days from the Georgia courts. But you can imagine a case where a state fails to submit its slate by December the 6th, and where the question of whether a tardy slate of electoral college voters is counted comes up to the Supreme Court through the judicial review provision that's in the Electoral Count Reform Act. That's pathway number 2. Pathway number 3, and I'll try and do this really quickly, is, as Judge Luttig explained, the Supreme Court in the Colorado primary ballot decision essentially punted. It declined to say whether former President Trump was covered by Section 3 of the 14th Amendment as an insurrectionist because of his role on January 6th. it punted because it said, well, that decision is for a federal, not a state actor to make. And it pointed to the fact that in the process of determining whether a senator or a representative can be seated, each House of Congress has exercised authority pursuant to Section 3 to decide whether somebody can be seated or whether they must be excluded under Section 3. Now, if one House can exercise that power, why can't two? Why can't the joint session of Congress that meets in the wake of the election exercise the authority under Section 3 to decide that somebody is an insurrectionist under Section 3 and therefore not eligible to take the oath of for the presidency? Obviously, it's unlikely that Congress, as presently constituted, would take that vote. However, there are mechanisms within the joint Congress for a minority, 20%, to raise the issue and perhaps force a vote on the question. And where the vote fails, it's not entirely clear that that minority would lack the power to challenge the joint session's decision in a federal court. Indeed, there is a provision in the Electoral Count Act that seems to allow that kind of substantive challenge and litigation on the merits of the question. And were that to happen, one can imagine the question that the Supreme Court punted back in the Colorado case, coming back to the court essentially on January the 7th for resolution before January the 20th. And for all the reasons that Judge Luttig said, I think we know how that case is going to turn out.
Yeah, it's something you don't really want to
certainly put the court in a hot spot.
Yeah, that's one of these moments where if you're relying on this court to save democracy, you probably are a little too late. But Aziz, thank you for that rundown and that piece. I can't recommend highly enough to those watching here. We can put it in the chat, the link in the chat for those who want to read it. Because Aziz was talking about the cases in general, I want to go to Adam because you're in Pennsylvania on the ground floor right there as these battles are being waged. And what Aziz talked about earlier, the first bucket of cases he's talking about are these Moore v. Harper challenges where state courts are interpreting state law, but the Supreme Court could very much jump in and say, yeah, but you got it wrong, state court, and you got to have the state legislatures handle this issue. So I want to ask you that's one way to get these cases to the Supreme Court. How has that affected the Pennsylvania litigation that you've either been witnessing or been involved with so far?
Sure. First of all, thank you so much for having me here, and I'm thrilled to be with such amazing panelists. And yes, I'm based in Philadelphia, Pennsylvania, during a presidential election year, which very much, it's like Tevye's line in Fiddler on the Roof. We understand that you're our chosen people, but could you maybe choose someone else next time? We know we're at the center of the storm, and there's a lot going on. And yeah, these Moore v. Harper issues have come up before and will come up again. 4 years ago, amid COVID, our state Supreme Court interpreting our state constitutional protection of that all citizens have a right to vote in elections that are free and equal, used that as a justification for extending the receipt deadline for mail ballots from Election Day to 3 days after Election Day. And the U.S. Supreme Court split 4-4 and therefore holding the decision in place, with the 4 dissenting justices believing that our state Supreme Court had gone too far in interpreting a state constitutional provision. And yet we have every reason to fear that that's going to happen again, as to other things. Election season in Pennsylvania doesn't start after Election Day, and we are dealing with a variety of cases right now, both on offense and on defense. On defense, 6 Republican congressmen have brought suit in federal court, challenging the way that we handle military and overseas absentee voters this year, as to saying that they should be required to give more proof of citizenship than what Pennsylvania is doing, which the state believes is absolutely consistent with its obligations under federal law. So they are trying to throw out military and overseas ballots right now. There are Republican challenges to the use of notice and cure for defective mail-in ballots. You know, when you send in your envelope and it comes in and a voter forgot to sign the ballot or forgot to put the current date on the envelope before sending it in, whether those states, you know, whether there's an obligation to let that voter know before election day so that they could take steps to try to secure their rights, either through casting a provisional ballot or otherwise. That is being challenged. There is offensive litigation that's going on that's trying to establish that there is a due process right to have that notice before election day. There are cases about whether it is required that if a voter finds out that their ballot is defective, that they have the right to cast a provisional ballot and have that counted because your first vote was never really cast. I mean, that's all already under works. What happens after election day is anyone's business. 2020 was a perfect storm in a lot of ways because Pennsylvania had a new law allowing for anyone to vote by mail, which was enacted in October of 2019, well before COVID. It was a law that, you know, had like any major piece of legislation, had a lot of open challenges to it, you know, both on the details of how it was to be interpreted and on the macro level, as we saw after election day, as to whether it was constitutional at all for the right to vote by mail to be extended in that way. We had a series, and I predict another series of internal Bush v. Gore-ish challenges as to whether, you know, as to whether variances in how counties apply this law, Act 77, as to whether that deprives anyone of equal protection rights. During the 2020 cycle, a lot of these cases were litigated, and the courts, and I have to say, including Republican federal, you know, Federalist Society approved judges, all sort of said, you know, Bush v. Gore does not constitutionalize every jot and tittle of state election administration. So they've allowed some play in the joint so far, but we don't know what's going to happen this year. But yeah, I mean, everything that we are litigating and everything that our courts are deciding, you know, we have a intermediate appellate court, the Commonwealth Court, which specializes in election law and governmental related matters. We have a state Supreme Court, you know, with 7 justices who now have all been through the storm of election litigation before. I think.
And Adam, can I interrupt you for there for a second? Because your state Supreme Court in recent days and weeks have almost fallen on a grenade to voting against voter rights, really. So to prevent these cases from being plucked by the Supreme Court to make, I imagine, worse Moore v. Harper law. And there's like this contest between the Pennsylvania legislature, which is still, I think, at least partly Republican, and the state Supreme Court, which is majority Democrat. And like there's like real politics stuff going on too, just to keep these cases from getting to the Supreme Court. At least that's my read.
Yeah, oh, absolutely. It was deeply frustrating. We've had a recurring issue under Pennsylvania law with regards to so-called undated ballots which are voted by a voter, received by their county board of elections on time, timestamped as being on time, but where the voter neglected to handwrite in the date of voting. And the statute says, you know, the voter shall fill in, sign, and date the ballot. There have been challenges both under federal statutory law, U.S. Constitution, and under the state constitution most recently, that free and equal elections clause, as to whether this was, you know, more burdensome than is necessary to further any state interest, because no one has really identified any state interest in this. And there was a strong, bold 4-1 decision from the Commonwealth Court about a month ago saying, yes, the free and equal elections clause means that this statutory term cannot be used to disenfranchise voters. And yeah,
Then the Supreme Court of Pennsylvania
Yeah.
said, we're getting out of this. We're staying
yeah,
out
we're
of
getting
this.
out of this.
And
It's
the
too
U.S.
close
Supreme
to
Court, the
they
U.S. Supreme
use,
Court
you
is now
know,
considering the same very issue on the federal side. And so like this is like, and what we're talking about here, Adam, it seems like these are small things, but like this is stuff at the margins in which elections are won and lost, which is why the Republican National Committee is bringing these suits, not the ballot sleeve one that was brought by voting rights plaintiffs, but across the country, a lot of these issues are brought by the Republican National Committee in the Trump campaign in order to make different gains at the margins in close states. And sorry to interrupt there, Adam, but I do want to get to Madiba on this, because we're also seeing the RNC bringing suits in various states. Mississippi, where Trump is going to win, Mississippi, Nevada, which is going to be more of a battleground state, saying that these states which have state laws that allow the election administration to count validly cast votes, mail-in votes that arrive after election day for a certain amount of days, 5 days, 4 days, a dozen days, what have you. This was an issue in the 2020 election, but it's now one that the Republican National Committee is bringing suits in these various areas. And the Republican National Committee lawyers before the Fifth Circuit, which this case was argued in the Mississippi case a few weeks ago, were saying, well, originalism demands that the election ballots have to be counted on and by election day, and no later. These state laws are unconstitutional. So it was always thus for a really a tactic that emerged from Donald Trump's head 4 years ago, that like how does originalism comport with this raw and rank and newfangled partisanship?
That is a great question. I do always find it really entertaining when originalism is presented as a reason why something new has to happen. So for viewers who may be unfamiliar with the concept, originalism is this legal theory that is really promoted by the conservative legal movement that says that the meaning of the Constitution is fixed in time, it's frozen at the moment of enactment, and however it was understood then, allegedly, is how we have to understand it now. And so we, excuse me, so in these cases, the RNC and other like Trump-aligned organizations are now making the case that under originalism, we can't count validly cast ballots if they were not received by election day. So these are ballots that were postmarked, sent, but arrived afterwards. And the Republicans are saying that when Congress passed these election laws, they required ballots to be received by election day itself. That was the original public meaning then, so it has to still govern now. This is foolishness for a couple different reasons. One is that it's not necessarily true that this was actually how things were done, considering this is like a novel argument that's being made. And second, and perhaps more importantly, even if it was true, so what? There's not really a legitimate reason why this should be the governing standard. It doesn't actually make sense to prevent states from responding to the needs of their constituents and doing some sort of common sense decision making to let folks who properly cast their ballots still have their votes counted. It doesn't make sense to say that the Constitution, which is in theory at least supposed to facilitate the nation's democracy, actually has to prohibit valid democratic participation. And this, I think, really sort of underscores the point that I make throughout my book, The Originalism Trap, about like how originalism is really just used in order to entrench the conservative legal movement, to keep them in power and to withhold power from a majority of the electorate.
Yeah, I mean, it's no coincidence really that we're hearing these hyper-partisan arguments wrapped up in these originalist or hyper-partisan positions wrapped up in these originalist arguments, because they're intertwined, right? There's this project is all part of the same ecosystem. And Madiba, you've written about that in the book that I see emblazoned behind you, The Originalism Trap. Like, give us some, like, just a small bit of that historical background, and then I want to bring in Lisa Graves, who will really give us a deep peek under the hood of what's been going on here and how this isn't all just a coincidence.
Yeah. So originalism really developed as a backlash to the successes of the civil rights movement, and it's been used to give a legal sounding cover for standard reactionary politics. And this has been used more and more as groups like the Federalist Society really promoted originalism and mainstreamed it and got it accepted to be the now dominant method of legal interpretation. And we've seen this used in a bunch of different ways, but I'll specifically talk about the voting realm for now, to basically allowing conservative justices to say, if I claim that this thing happened before, now it's fine, and now it has to happen presently. And they're using past injustices to validate present ones, and to try and like lock in unfair, undemocratic situations, and saying that like that's actually what the Constitution requires, even though provisions of the Constitution, like the Reconstruction Amendments, were expressly designed to prevent things like this and allow a multiracial democracy to flourish.
Reconstruction amendments that the Supreme Court has done a fair share in gutting, most recently including the Colorado ballot access case that Trump brought, in which the insurrection clause was rendered a dead letter by at least 5 justices of our Supreme Court. Madiba, this is a pattern that we've been seeing, and now has been supercharged and almost magnified since 2020. And Lisa, this is where I want to bring you in, because one of the cases we're seeing now are the Republican National Committee's voter roll purge cases. You're seeing these across the country, and in one of them, the State Board of Election is removing one of these cases, I think in North Carolina, over to a federal judge who happens to be Richard Myers II, a Trump appointee who has belonged to the Federal Society and the Christian Legal Society since 2004. And he also was one of the first people to gut the 14th Amendment's insurrection clause back when Madison Cawthorn introduced it after January 6th. And it was way further than the Supreme Court actually did. So this removal from state court to federal court might be a random assignment to this particular judge, but the possibility of this happening wasn't really by chance, was it, Lisa?
No, and thank you so much, Mike, for that introduction. And it's a joy to follow Madiba and be part of this panel. And it's been a joy to work with you and Alex Aronson at Court Accountability. I just want to say, I guess to draw the lens back to your point, and I think some of the other points, there's no doubt that there's judge shopping going on by these, people who are devoted to making it harder for Americans to vote, and in essence, trying to use the courts to put Donald Trump into office. I want to talk a little bit about some of those groups, and as you said, Mike, sort of the origin story here, because it's not just happening in a vacuum. What we have is a whole ecosystem that has been created to try to make it harder for Americans to vote. And I would be remiss if I didn't say, just to pause and say, what a different world it would be if Judge Luttig had been put on the U.S. Supreme Court instead of John Roberts, given what Roberts has done and the machinations he went through in order to keep Donald Trump on the ballot in this election and to make it impossible for the criminal case to go forward, the trial to go forward before the election this year. But when you look at what's happening, it's not just Trump litigating. It's these groups that are very closely tied to Trump that are moving these cases forward. So, for example, you have a group that calls itself Restoring Integrity and Trust in Elections, RITE. Who funds it? One of Trump's biggest funders, Steve Wynn, the casino billionaire. Who leads it? A guy named Derek Lyons, who was the right-hand man, the staff secretary basically for Donald Trump during the Trump administration, and who clerked for Brett Kavanaugh. Brett Kavanaugh actually had that role as well in the George W. Bush administration. But Derek Lyons is not just that guy. He's also the guy who worked with a thing called the Judicial Education Project, which, not to have too much alphabet soup, is another group that's involved in these cases through its alias, which is known as the Honest Elections Project. So you have people who are at the center of this litigation, who are bringing these cases, doing this judge shopping, trying to change the rules for voting as people are in the process of voting. And they have deep ties to the money infrastructure that helped capture this U.S. Supreme Court. So you have Leonard Leo obviously is the person who's been most closely tied to the Judicial Education Project, which, as I said, has this alias, the Honest Elections Project. Leonard Leo has helped inject more than $170 million into the Judicial Education Project alone. We believe that money has come from the big trust that he received a few years ago called Marble Freedom Trust, which is the $1.6 billion gift Leonard Leo got after he helped capture the US Supreme Court. So here you have litigation moving toward the Supreme Court that's being fueled by the man who helped get some of these judges installed on the Supreme Court, and by operatives who have worked closely with him on basically laundering the big lie from 2020 through groups like the Honest Elections Project, trying to make it harder for Americans to vote through changing the state laws and then using the courts to litigate them. We're seeing that litigation from RITE and Honest Elections Project in a number of states, including Arizona, in the Mia Femia case. We're seeing it in Montana, for example, where they've jointly submitted an amicus brief, basically trying to move that door open from Moore v. Harper to let the Supreme Court say that state courts that protect voting rights cannot do so, that legislators have the final and only say about our voting laws. And this is all happening in the context of a US Supreme Court that, as Judge Luttig set forth, so clearly has put its thumb on the scale of justice in these rulings and immunity, and also in the Colorado case, in the Fisher case. And let me just conclude with this, which is you have a US Supreme Court where, not only do you have members participating in those decisions who should not be in those decisions, like Clarence Thomas, with Jenny Thomas's active role in trying to subvert the 2020 election and even instigate these fake electors in Arizona and Wisconsin. You have Sam Alito with the revelations of his role and his wife in terms of flying these insurrectionist flags after January 6th and more. You have 3 justices on the Supreme Court who actually were lawyers involved in the Bush v. Gore litigation. That's John Roberts, that's Brett Kavanaugh, and that's Amy Coney Barrett. And you have a situation in which this Supreme Court, in essence, has been corrupted. If Thomas and Alito had not participated in that immunity case this summer, it could have gone the other way. But that's not the only thing that's happened. In Bush v. Gore itself, we know that Clarence Thomas participated in that case, even though his wife, Jenny Thomas, was working for the Heritage Foundation to pick people who would go into the Bush administration if he won, and was rewarded by becoming the top highest paid non-board member of the Heritage Foundation after Clarence Thomas cast the deciding vote in that 5-4 decision in Bush v. Gore. That decision in Bush v. Gore happened in just 4 days from the Florida Supreme Court decision allowing those votes to be counted. So we are facing a significant and substantial threat in this cycle from this Supreme Court of a Bush v. Gore 2 by justices who should not be sitting on these very cases, but who are paving the way for the type of litigation that is being filed in state after state after state. So I'll turn it back to you with that, Mike, and thank you for letting me speak into the next hour.
Well, now that everyone is terrified and our hairs are collectively on fire with a very, very concerning report you just gave us there, Lisa, that is an excellent, frankly, way to close out this this panel, because everyone here watching is here to understand the election interference threats that are heading to the Supreme Court's way right now. And it's not just these discrete cases that are being randomly thrown into various pots to hopefully find the way to the Supreme Court. There is an ecosystem involved here, as Lisa so well detailed, that has deep historical pedigree that Madiba so well has chronicled, that is being played out in each state, as Adam can so attest to in Pennsylvania, and has multiple pathways to the Supreme Court, as Aziz himself did detail. So thank each of you panelists for joining us here. Everyone watching, we are 5 minutes over, but I hope that 5 minutes was well worth your time. It was worth mine for sure. And I hope that you will all continue to pay attention to what's going on and keep your voices loud and clear as we follow these cases over the next weeks, and hopefully not several many more weeks beyond that. Thank you for watching. I'm Mike Sachs with Court Accountability. Thank you, Dahlia Lithwick and Judge Luttig, for joining and starting off this event. And again, thank you all for watching. Have a great day.